Hello, good night. Welcome to Legalize. Tonight I have as co-host Senator Andrew Lewis, who is the President General of GTAO and President of Grenada Trade Union Council, and also President of Caribbean Congress of Labor. We have as our guest Ms. Danyish Harford, a young attorney at law who recently graduated from Bristol University in the UK with a Master of Laws degree in employment law. As a small jurisdiction, there are not many lawyers who specialize who specialize in postgraduate training, though the trend is growing. I'm aware that in recent times, lawyers have done postgraduate training in environmental law, financial services law, legislative drafting, human rights law, commercial and corporate law, intellectual property law. Of course, Dr. Francis Alexis is a long-standing PhD in constitutional law, and Dr. Lawrence Joseph has also done a PhD in public law. However, I do believe that Ms. Harford is the first Grenadian to do a Master of Laws degree in employment law. I have checked experienced lawyers, and they do not know of any other. But of course, I am subject to correction. Employment law is not to be viewed only from the standpoint of labor/employees. It is also to be viewed from the standpoint of employers, and indeed, there is a strong public interest in employment law. Employment law is particularly relevant in Grenada at this time when there are issues of public sector regularization, statutarization of hospital services, occupational health and safety, and several issues of the labor code. All these touch and concern issues which Ms. Harford would have covered in a course, if not directly, as discrete topics. Certainly, the principles she would have mastered would be applicable. Ms. Harford is young and new, so we will not be putting her on the spot to address those issues, unless, of course, she chooses to do so. What we'll want to get from her tonight and for her to share information gathered from her training, which she believes is relevant to Grenada and the wider Caribbean. Andrea and Ms. Harford, good night. But before I ask you to give any introductory remarks, I just want to recognize the sponsors of this program: Jail Professional Solutions, GEM FM carrying this program on FM radio station in Canada, and Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Senator Lewis, good night, and thank you for being my co-host. And Ms. Harford, thank you for being our guest. So, Senator Lewis, you want to say anything before we go into the meat of the matter?
Sure, most definitely. Thank you very much for having me as your co-host on a most important and relevant topic, and more so to be co-hosting the first known, certainly to myself, counsel, lawyer that has done postgraduate study in employment law. That's my understanding. And I hereby take this opportunity to publicly congratulate and to salute, not lightly, salute Ms. Harford for undertaking that field of study. And Grenada must be the better for it as time goes on. So I look forward to this engagement. Thank you.
Yes. Good evening.
So,
Thank you, Mr. Lewis, for the warm welcome. Yes, I'm excited to get into the gist of today's session.
Okay, so I guess we are interested in knowing, and I guess the viewers are interested in knowing, who is Danyish Harford. It's a new face on the scene in Grenada, and based on the limited experience I have, I believe it is a face that will be around for a long time. So who is Danyish Harford?
Yes. Well, that's a very difficult question to answer. First of all, to summarize who you are in a short paragraph, I would say. But at this stage of my life, I would say I am an excited young attorney at law. I'm looking forward to growing in the profession and effecting some change, particularly with my experience or exposure, rather, to employment law gained from my master's. But before going into the master's, of course, I started off in secondary school at the St. Joseph's Convent. After that, I pursued my associate's degree in law at TAMCC, where I graduated as the top law student and top in the social sciences department. So my interest in law was really kindled from my mom, who was a prosecutor for many years, and she would come and speak about, the matters she dealt with in court. So I became intrigued. So I decided to, see how it was in TAMCC. I enjoyed it. And, but before making the leap to go into UE, and, that's a big decision to make. It's 5 years of study in total. I undertook an internship at Siboney Chambers under the tutelage of Mr. Ferguson and the other experienced staff. You as well, Mr. Layne, at Siboney Chambers. And that year-long internship really instilled in me, I believe, it kindled the fight for justice, I would say. Siboney takes on a lot of the constitutional matters, employment law matters, and, just pro bono deals with the people. So I think that year-long internship at Siboney Chambers really cemented in me the desire to pursue law. And then afterwards, I went on at UE, Cave Hill, completed Hewardin, and then returned to Siboney for 2 years before going on to do the master's program. And now I'm back at Siboney, excited to continue the journey.
I know that, is there anyone else from your class at St. Joseph Convent who also went into the legal field? I'm told that there's one class, there are about 7 or 8 lawyers in Grenada who were in the same class at St. Joseph Convent many years ago. So I'm just asking.
Right. Maybe not from my year, but from the year before me, there's Miss Noel. She also undertook a master. Cherise Noel undertook a master's in the same year I did, in arbitration, I believe, and Tira Dumont as well. Not from my year, but from the surrounding years, yes. So St. Joseph's Convent seems to have, to incite some sort of desire in the young ladies to go on to law.
Okay.
Yes.
And then from there, I went to TAMCC, and it was a two-year course?
Yes, it was a 2-year course. And of course, I must mention the lecturers who were instrumental, Ms. Jasmine Redhead, who I now call Auntie Jasmine because of her support, her great support. And of course, Mr. Albert Mitchell. They were very, very instrumental in the in my pursuing the law.
Okay. And do you want to come in at all yet?
Just to note, and for the viewing and listening public, and certainly the younger ones, that with discipline and a sense of focus and direction, one can actually make it. Because what I've gathered from you, right, is that, as you said, making that decision to go to UE, in other words, putting aside 5 years, a minimum of 5 years, what it shows is that 5 years will pass, and 10 years will pass, and 15 years will pass. So you would be an example for certainly your peers and younger, that the journey starts now.
Yes, certainly.
And so you went from TAMCC, you did 1 year at Siboney, and then you went to Keyville. What was your experience at Keyville like? And Keyville meaning University of West Indies in Barbados, right?
Yes, correct. Well, I quite enjoyed my Keyville experience, not just the academic aspect, but of course the extracurricular activities, because I was involved in student bodies like the Grenada Student Association at Keyville, GrenSAC, UE Stat Student Today, Alumni Tomorrow, and also the publication committee of the Guild of Students. So I believe UE is more than just a place to go and learn, the academics, but it develops you greatly as an individual, living away from your family, of course. Have to make some, I would say, big girl decisions for the first time. So it definitely instilled their sense of responsibility, and there I feel like I grew into my own in that environment. Interacting with all the different students from the Caribbean obviously opened my eyes as well. But focusing on the course itself, of course, that provided the foundation for the studies to move on to Heward, and where you get the more practical aspects. And it was very enjoyable. There were the mandatory courses for the first and second year, and in the third year, you had the choice to choose your courses. And that's where I really enjoyed it, because I had the opportunity then to choose the areas I was interested in. And of course, I chose employment law. I did 2 employment law courses, the only 2 that they offered, which were employment law and introduction to discrimination in employment law, I believe. So yeah, UE definitely also had a role to play in me furthering employment law, because I did get an introduction into the field there.
Interesting. Yeah. And of course, you would have been able to, as you said, interact and build a network with students across the region. And then that would have flowed into Heward Law School?
Yes, definitely. And I would say I've made lifelong friendships at UE. And not just the students, the faculty as well, because Honorable Cumberbatch, the Justice of Appeal from Barbados, who recently passed, he was my employment law tutor. He was also he was my supervisor for my research paper on an employment law issue as well. And he was instrumental in me. He provided a reference for me to get the Chevening Scholarship. So the faculty they're very important in my development, in addition to the student relationships that I cultivated at UE.
And the experience in Trinidad, how did it compare with or contrast with that in Barbados?
It was definitely very different. It was a more professional environment compared to UE. Of course, even the way you dress, you had to dress as an attorney in training at the Heward Law School. So in professional wear. And it was a much more practical course compared to UE, where you were learning the fundamentals, the theoretical aspects of the law. At Heward, we were exposed to moot court, cross-examination, trial. So we had to do both a criminal and civil component of that trial advocacy, as they call it. So it was, and more so to the procedural aspects of the law, which is relevant, when you actually become an attorney and you're practicing before the court, filing documents. So it was much more practical than the UE component, for sure.
Were there any employment law courses at UWorth?
Unfortunately, no employment law courses, but the exposure to the civil procedure, both 1 and 2, it was separated into 2 different courses. That obviously was very relevant because employment law matters typically, aside from the unfair dismissal regime, which I'm sure we're going to get into later on, follows the stages of a high court civil matter. So what we did learn, it is relevant to how employment law is litigated in our system.
Okay. And so you completed UWorth, came back, was called to the bar. You have been practicing before the courts for the last few years before you went off to England. Your course in England was how long?
It was a year long, so from September 23 to 24.
And you did it at Bristol University?
Yes, I did.
And why Bristol, by the way?
Well, Bristol was really the only university in the UK and Wales that offered such a specialized employment law course. Because through the scholarship I got to go and study, there's only a UK and Wales, and Scotland, just the United Kingdom really you could study in. And I obviously did my research on the different universities, looking for the best course, and University of Bristol had what I perceived to be the best course. Very specialized. They had experts in the field as well, who obviously you want to learn from. So that's why I chose University of Bristol. And the designation for the master's is employment, work, and equality. So there was no other university that offered such a specific course.
Okay. And in your period prior to going off to Bristol, is there any case that you would have been involved in, or cases which would have piqued your interest?
Definitely. So there was the Indra Williams case that went all the way up to the Privy Council. The matter was Mr. Ferguson, King's Counsel from Siboney Chambers, was the advocate in that matter. And I was involved in the, research process. So that definitely, I think, kindled, or it further fueled my interest in employment law, based particularly on the judgment, which was unfortunately not in the employee's favor. And that, in my opinion, was a grave injustice. The court itself didn't believe it could give us the remedy the employee was looking for. So I guess in the legislation that actually exists in Grenada, which is the unfair dismissal regime,
which we'll come back to.
Yes.
In a while, in terms of the legal framework that exists in Grenada now. Have you been able to, before we go into more details on your course, compare the legal framework, legal employment framework, what exists in Grenada with what exists in other Caribbean countries?
Yes, not in any great specifics, but in a cursory way, particularly with respect to the employment tribunals that Antigua has and Trinidad has and Grenada does not have. So I actually did a research paper at UE on assessing the efficacy of the labor commissioner in terms of his role in labor disputes, compared to those systems, Antigua, for example, that do have a labor tribunal. So that is a particular point that I was interested in, since at UE, looking at the actual mechanism for enforcing rights and whether or not it is even adequate. So Grenada, well, like more of the Caribbean countries, as opposed to being the point of distinction, does not have an employment tribunal to deal with employment-related matters.
Okay. Andrew?
Yes, well, Dinesh sort of addressed one of the issues that I wanted to raise, but she may wish to elaborate as to whether or not her earlier stint in Siboney, as she indicated, how that impacted her final decision. I know that you spoke generally of Mr. Ferguson Casey, the aspect of pro bono, the aspect of social justice, picking your interest, and certainly the Inja William case as a pinnacle, where you thought most likely that at the level of the Privy Council that is expected to bring quote unquote justice to matters like these that you felt strong about didn't come the workers' way, right? But I am taking it that certainly your engagement in Siboney form part of that foundation in terms of your consciousness in seeking to build and pursue your studies in employment law. Yes?
Yes, definitely. And, Siboney has a particular culture, as you said, of social justice, more for the people kind of firm, champion of the workers. Well, I wouldn't say champion, but litigating, certainly advocating on behalf of workers. And certainly we're not, saying we don't represent employers as well and recognize that they also have certain rights. But certainly from the party that it's presumed to have the lesser bargaining power in the employment relationship, Siboney Chambers definitely represents quite a few of them. And my exposure to those sorts of matters and just the consciousness, I would say, that the partners at Siboney and the staff, they exude, it definitely had an impact on my trajectory.
Just, Layne, if you would permit me, just in terms of full disclosure, I should just let it be known that Siboney is the legal retainers for the Grenadian Technical and Allied Workers Union. Just thought I should, in terms of full disclosure, just thought I should put that on the table. Yes,
and of course we openly disclose by way of paying tribute to the fact that I was one of the sponsors of this program here, which many people have said it's important. It plays an important role in terms of providing general information on legal matters, matters which affect the public. Yes. So Danyish then now, so you now leave for England, and I guess it was your first time out there?
No, it was not. It was my second time there.
Out in England, yes. Mm-hmm. But first time as a student?
Yes, first time as a student.
And you have a full 12 months. So tell us something about the course, how it was, and that's what we certainly I am interested in hearing a bit more about, and how it could be relevant to the Grenadian society and the wider Caribbean society.
Yes. Well, it was a very enlightening course, enjoyable as well, learning from, experts in the field. Professor Alan Bob, who advocated before the Supreme Court in salient employment law matters. In fact, we were privy to some decisions as they unfolded, such as the Deliveroo decision. It was particularly relevant because, the gig economy and platform, this type of work is very prevalent in, the UK and the US. And how it relates to Grenada, definitely it does, because, we have these ride share sort of apps like Hail Up in Grenada. And food delivery services. Well, I'm kind of getting ahead of myself,
Okay.
but the course, it focused very heavily in the initial stages on the distinction between a contract of service, which is an employment contract, and a contract for services, which is provided by a self-employed individual. Both related to services, yes, but the designation carries a very different weight in law, where you have a contract of service, an employment contract. It opens up a flow of rights to the individual, such as, minimum wage, um, leave entitlements, dismissal, all these sorts of things. Whereas contract for services, which leads to a self-employed designation, you are basically shut off from those statutory rights. So that was a big focus in one of the courses, the individual employment rights courses. There was also a collective course, workers' unions and collective labor rights, which focused more on the industrial relations aspect, how trade unions operate, the right to freedom of association. So we had these two different vantage points, the individual aspect and the collective aspect, which
so
are...
in terms of the individual, just to go back a bit, if I may, just to see I get you and the viewers could get you. In terms of the individual aspect, you see that you have people who are strictly employed. They work for employer.
Yes.
Contract of service.
Yes.
Right. So it's an employer-employee relationship, sorry. And then you have the others now who may provide a service, but they provide it independently. So essentially, they're on their own.
Correct.
Right. So,
Yes.
for example, you may have somebody who, I think you were given the example of the food, somebody who supplies food, let's say, for a business place. They have their own business and they supply food for the business place.
Well, that too, but...
Sorry. That could be one relationship, as well as you may have the business place itself now deciding that it will supply food for its employees as part of its operations, and then employing somebody within the business to actually do the cooking and the supplying of the food. That person will be an employee.
Correct.
And the first one I'm speaking about, with their own independent thing, providing the food to the business probably then supplying the food to his employees, that person will be the independent contractor?
Yes, that's the typical designation. Yes.
Okay, good. And of course, you see these are different relationships, different rights flow from them, and that was an aspect of your study.
Correct.
Right, sorry, but I think I took you off course a little, so
sorry. No, that was an important point to clarify.
Yeah.
But what was interesting in the course is that, and I had gotten some insights in it previously at the employment law course in UE, is even though where someone may be designated as an independent contractor or a self-employed individual, and the contract refers to them as such, there may be certain factors in the relationship which kind of gives you the hint this really isn't what it seems to be. So even though the contract says one thing, the actual relationship, how it occurs, it's different. It seems more like an employee as compared to an independent contractor. And sometimes the court has to peel behind the contract, what is on the face of it, and assess what the actual relationship is. And the court may find that even though they are designated as such, in truth and in fact, they are an employee. And so they are entitled to those rights. that an employee would be entitled to.
So I guess a typical example may be with the where the issue may arise is with the 21st century trend of outsourcing, allegedly.
Yeah.
So a business may appear to outsource a particular service, yeah, and they may say in the contract that these people are independent contractors, but then an issue may arise. So, for example, somebody may get damaged or injured on the during the course of the employment, during the course of carrying on a function, and they want to claim from the employer.
Yes.
And I guess in a case as that, they will say, well, notwithstanding that the document I have say that I'm an independent contractor, in practice, I am in fact an employee, and therefore I'm entitled to certain protection. That's a relevant scenario.
Yes, yes, and it is an apt representation of how it is. And while at the end of the day, they may set say the contract is sort of a sham contract. It's not really representing the facts on the ground.
Realities.
Yes, exactly. That doesn't mean the contract is, they're just going to disregard contracts of totally, because there's the freedom of contract. Parties have they enter into these terms and conditions. So it's not something that is lightly set aside, because at the end of the day, there is still that important principle, contractual principle, that stands. And barring that, people would just, one may say, it could create some sort of confusion as to whether or not you enter into something, and then some other indication.
When trouble comes, you say, nah, not really, that was something different.
Yes, exactly. So there must be, some significant indication, and the particular factor that the court looks at is whether the contract is performed personally by the individual, whether the person who has engaged the independent contractor's services, exerts control over them, whether they are integrated into the business, whether they are in business of their own account, whether they expend all the monies in whatever the contract relates to. So there are certain tests that need to be satisfied. So it's not just you come in court and you say this, and then the contract is put aside. Yes, there is a stepped approach. There are significant considerations that have to be met, and the court looks at the contract. That's the starting point. But if there are indications to the contrary, then, and clear indications, the contract would be set aside.
Yes. In those circumstances, would the bargaining power of the parties involved, would that be a consideration?
Yes, it is. It is a consideration. And in fact, there was a case that we were exposed to that I just can't remember the name now, that clearly recognized the unequal bargaining power in employers and employees, or where it's the independent contractor and they've been designated as such, the person who has been contracted to provide the service. Because at the end of the day, there are very little individuals who really have the weight to say, you know what, I want this, I want that in my contract. Usually it's on a take it or leave it basis. The person, the person who wants the services presents a contract. They say, hey, this is what I want from you. I mean, there may be negotiations on the sum and so forth, but in terms of the actual designation, whether you are an employee or an independent contractor, you don't really have much say in that, because at the end of the day, persons work particularly because they need to make a living, and they're not going to give up a contract because they're not designated as an employee. So that inherent and equal bargaining power has been recognized in the employment relationship, and it is a consideration. but it's not the determining factor.
It's not
There still
conclusive.
have to be the
One of
other.
the factors that they weigh up.
Yes.
And of course, in most of these circumstances, the stronger party will be the one who drafts the contract.
Yes.
And that will also be a consideration, do not conclusive by itself.
Yes, correct. That's also a consideration.
Okay, so tell us, besides you did courses that would assist you in those circumstances to differentiate between modes of employment, and what other courses? Because that was the individual ones and then the collective ones.
Yes.
Mm-hmm.
I also, I had the choice of choosing the other two courses. Obviously they were streamlined, so I can't just jump from employment law to, let's say, I don't know. Nothing is coming to mind. But okay, so maritime. So I can't just select a maritime course to go along with my employment law course. So there are streams. And I chose from the options that I could have chosen from insurance law and company law as well, because I feel that it marries well into the employment law discourse. Company law, well, oftentimes it's companies that employ employees. And they also need advice on, as you said, employers also need to be okay with whatever rights and obligations. And then insurance law as well. That's just my personal interest in insurance.
Interesting. Okay. Yes. So, so tell us a bit about the collective part now.
Right. Yes, the collective aspect. So we certainly had the individual, as we discussed. The collective aspect of the course dealt with trade unions and how they obtain recognition from the employers to be the official bargaining agent for a set of employees. Also the right of freedom of association generally, and how it filters through, which is set out in the International Labour Organization, the conventions. It recognizes a right for persons to enter into trade unions, but contracting states or states who have ratified the conventions have a margin of appreciation for how they give effect to that international standard, labor standard.
But that would mean that they don't have to, everyone doesn't have to do it exactly the same way.
No.
They will recognize that every party has a small margin in which they can operate and in which they can introduce some differences and distinctions. Yeah? But let me ask, as part of the course, did you trace the history of the trade union movement and so on? Because even in England at one time, trade unions were lawful, and it was criminal to engage in a collective. In fact, it was considered a criminal enterprise.
Yes. Yes. So in the collective aspect of the course, we certainly delved into how trade unions, or combinations as they were called previously, were illegal at common law. And with time, statute was enacted that, piece by piece gave them some leeway to really act. So that certainly was an aspect of the course. But aside from the course, in my dissertation, I, through my own interest kindled from that aspect of the course, I undertook a historical comparative analysis of the UK trade union legislation and from the Caribbean as well. Obviously, it cannot be too in depth because it would be very expansive to get into all the legislation from the UK and the Caribbean. But my research did trace the history of the trade union movement in the United Kingdom and compared it to the Caribbean, particularly Grenada, of course, And because, Britain was our colonizers in the Caribbean, I thought it would be a very interesting point of comparison and contrast to see how they treated their own workers and how our ancestors were enslaved, and the history of trade unionism, which was much it was more embryonic compared to the UK at the particular time. It was actually recognized as trade union, and trade unions were given that recognition rather.
And what stood out?
Well, the research was not just a historical analysis. It had to have some sort of finding. So it really compared the strategies or the methods that unions use throughout time compared to the prevailing legal regime. So really assessing whether a more restrictive legal regime, and that is an industrial relations regime, restrictive or hostile to employees and trade unions, what sort of actions do the trade unions, or illegal combinations as they were back then, took in response to that regime? So how did they give effect to their purpose of representing workers and promoting their best interests? And I found that across the UK and across the Caribbean, while the hostile legal regimes certainly perpetuated more radical methods, violent strikes, revolutions, revolts, sometimes leading in death, arson. Those were methods, yes, in response to the hostile regime, but also the ideological underpinnings of the people at the time was very, very crucial. The workers, the trade unions, in affecting the types of methods that they used. So, for example, the socialist ideologies definitely stemming from Marxism affected the actions that the trade unions took, and also the economic conditions at the time. So where there were more dismal economic conditions, more radical methods were used.
Yeah. And of course, the trade union movement was very important in the whole movement towards decolonization in the Caribbean. In almost every island, that process was led or heavily impacted by the trade union movements. That's correct?
Certainly, and that was also one of the findings in the paper. Many of our, first prime ministers or premiers were trade union activists in the Caribbean, and because the working class were so, I would say, oppressed by the colonial government, the labor movement being the one really pushing against and striving for independence, it only made natural sense. So definitely the labor movement is crucial.
But of course, 100 years later now, the situation is completely different. So I don't know if your that was part of your study, because many people are of the view that in the transformed socioeconomic circumstances in the Caribbean, maybe new methods are required. But I don't know if that was part of your study, and in particular, many of the view that other methods, and of course the law is even more significant now than maybe in the 1930s or the 1940s, and then Grenada in the 1950s. I don't know if you want to comment on that or not.
No, I do, and I agree. Because back then the trade unions were pushing against the law to achieve whatever rights for the workers, but now trade unions work mostly within the confines of the law. Now that there seems to be a stable industrial relations framework and recognition of employees' rights, so the approach that needs to be taken certainly cannot be the same as back then in a totally different context. And in fact, in the UK, there is what the I would say one of the more dominant methods used now is something called strategic litigation, where the unions really push against the law where it seems that it is detrimental to the employees through strategic cases where they believe, okay, we can get a win in this particular circumstance. But the difference is the difference between the UK and the Caribbean is that trade unions in the United Kingdom, they can institute matters in their own name and in their own right. In Grenada, at least, there is that restriction. Trade unions cannot sue or be sued. There's a very limited right, of course, only by the members could do so, or where it relates to certain lands. There's obviously an exception, but typically trade unions cannot sue or be sued in Grenada. So the ability of trade unions to make use of strategic litigation in their own right is different as opposed to that in the UK. But in the Indra Williams case, which was very crucial, the trade unions did, I know, have a really big part to play in that matter even moving forward. And that is an example of strategic litigation, where you're trying to push the boundaries of the law, where it seems as if there is a gap, and make some headway where the legislature really isn't, making any movement. Or and at least, sorry, even if there is not a finding in favor of the employee, there could be some statement from the panel of judges, as was done in Indra Williams, to say, okay, there seems to be an issue here that needs to be rectified by the legislature, if not by us.
Yeah, in fact, the Privy Council used very strong language, and in fact, both the High Court and the Court of Appeal called on the legislature to remedy this. And I think the Privy Council is the strongest in its language, saying that, listen, this is a recalcitrant employer who has just decided to essentially be abusive. But they then said that, look, we can't really do anything about it. It's the legislature to do something. So at least that litigation, if you consider it part of strategic litigation, at least one positive is that it highlighted a gap in the legislation that protects workers' rights, that cries out for a remedy.
Yes,
certainly.
I don't know if Andrew wants to come in at all on this point.
Well, sure. Because our union, TAU, was directly involved in this matter as the one providing trade union representation at the workplace for Indra Williams. And we felt, as we always do, that there are different arms of struggle, and certainly the legal arm is therefore one of them. And the role played by Siboney Chambers here, because as you would know, that these things can be extremely expensive, right? And therefore, the role and function of Siboney Chambers, KC Ruggles-Ferguson, and his supporting team, including yourself, and Mr. Layne, played an essential role in allowing us to be able to take this case to the highest level. But Danyish, I'm also interested in, during your research, the question of trade union recognition. Although it is a part of the convention of the ILO, as you know, it boils down to the national legislations and employers' willingness or strength of legislations, national legislations, etc., to give effect to this. Were you able to do a comparative analysis using Grenada, right, as your base, and any other Caribbean islands or so, to see the ease, for want of a better word, the ease or challenges to do with gaining trade union recognition for workers? And how did you find it?
Right. Well, unfortunately, I did not really conduct an in-depth analysis on the difference between recognition of unions in Grenada as compared to the UK. But just from my knowledge, what I recall, there are various ways of obtaining recognition in the United Kingdom. There's compulsory recognition, there's voluntary recognition. So even though an employer may not want to recognize a particular union because it may be a more, belligerent one that may fight more for their employees as compared to what they may call a sweetheart union, which the employer recognizes, that will really give way to their interests more so than promoting the workers' interests. So there is a voluntary route where there is consent, and there is a compulsory route where there's a certain amount of employees who wish for that particular union to be the one representing the interests, and that takes a certain course.
And may I ask, on the voluntary one, what you may call sweetheart, or in some other cases they may call them a yellow union. Yes, when there is this voluntary arrangement acceptance, are the unions able to pursue, if the need arise, certain actions against the employer to get it enforced within the court system?
Right. Well, that's the other aspect. Collective bargaining agreements are not enforceable in the if that's the question you're asking. It's not enforceable in the UK court. So it's you agree to them, but if there is anyone breaches a term, it goes through the industrial relations, whatever methods like striking or so forth to get compliance. But unfortunately, the court cannot compel an employer to comply with a term it's agreed to in a collective agreement.
Yeah, I want to come back to a question there, but just let me say, in terms of the Adrian Williams case, we have mentioned it several times. So Adrian Williams' case was a case involving unfair dismissal, and Ms. Williams alleged that she was unfairly dismissed. And the procedure in Grenada is that you make a complaint to the Ministry of Labor, and it is dealt firstly by the Labor Commissioner. Then, if it is not resolved at that level, then it goes to the Minister of Labor. And finally, it may go to an arbitration tribunal. In the Adrian Williams case, the Labor Commissioner made certain recommendations in her favor, but the employer said that they did not agree with those recommendations and the matter was not settled. It then went on to the minister, and the minister made more or less the same recommendations in her favor. And again, the employer said, we do not agree. So the matter was not settled. The employee was prepared to go to arbitration, but the legislation says, and it has been interpreted to say, that you cannot compel either party to go to arbitration. Yeah? So the issue that arose in that case was if the employer, as in that case, said, we're not going to arbitration, if that's the end of the matter, or whether you can proceed to the court for the court to make a determination of the complaint. And that's where the issue arose, in that the courts in Grenada and then the Privy Council all said that as unfortunate as the situation is, the court has no jurisdiction in this matter. For the matter to be resolved, both parties have to agree to go to arbitration. And if one party says, I'm not going, in this case, the employer says, I'm not going, that's the end of the matter. Nothing can be done. So that's the Adrian Williams case. Now, so I want to ask you now, Danyish, that regarding, you said that the courts cannot enforce, collective bargain, collective agreements in the UK. But isn't there a system in the UK, a tiered system for such determinations, a conclusive determination that is enforceable?
For collective for the enforcement of terms under collective bargaining agreements, there
Yes.
is no determination that can be made by the court. So it's outside of essentially the court system, at least as far as I'm subject to correction, of course, but that's just what I recall from.
But isn't there a tribunal system that you can go that?
There is a tribunal system, but
Right.
it's not to deal with matters arising from the collective bargaining agreement and its enforceability and enforcing that. So all other issues arising from the employer and the employee in unfair dismissal, for example, there certainly is a determinative route that can be taken through the employment tribunal, the employment appeal tribunal. So there is that specific system that is in place to deal with these sorts of matters. Now, the thing is, right, collective bargaining agreements, they can give more than the statutes have prescribed employees are entitled to. So the employer at the end of the day is still liable to the employee for all the rights they're entitled to under the statute. But where there has been any building up on those rights in the collective agreements, and then the employer says, "Hey, I'm not going forward with what's in this agreement anymore," it the enforcement of that agreement will not go to court. But whatever, if any of the statutory rights have been breached, certainly that is actionable. And
Okay, so sorry. Just to clarify, your understanding is that if, for example, under a collective agreement, it says that an employee is to be paid, let's say, overtime at a certain rate, right? Which is superior to what the legislation provides for. And the employer decides, you know what, I'm not going to pay that. I'm only going to pay what the legislation provides for. Based on your understanding, as of now, the employee cannot take that issue to a tribunal.
Unless that has been incorporated into the actual employment contract.
Individual employment contract.
Yes, the individual employment contract. So that's the route you can take to include whatever has been specified under the collective bargaining agreement to bring it into enforceability.
Right. So you're saying that the collective bargaining agreement will have to be incorporated into the individual contracts for that individual then to have a standing either before a court or a tribunal.
Yes. So it's not as if the door is completely shut, but there is an extra step that needs to be taken.
Okay, good. Before we go on, I just want to once again recognize the sponsors of this program: Jail Professional Solutions, Gem FM, carrying the program on FM out of Canada, and Grenadian Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenadian Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenadian Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Yes. So, Danyish, we invite the viewers to post comments. I'm seeing one there so far. On a humanitarian basis, the employer could have considered some form of compensation for the worker based on the years of service the employee gave to the employer in the Adrian Williams case. And then one person, GZL, is saying that I guess the matters we were discussing That's a contractual issue that if the employer decides they're not going along with what is in the collective bargaining agreement, then that will amount to a breach of a contractual right. So, sorry, Andre, you wanted to come in.
Yeah, let me just ask, what if the collective bargaining agreement clearly states, and obviously for it to be a collective bargaining agreement, both parties will have to sign, talking about the employer and the bargaining agent, that these terms and conditions are enforceable under the laws of which respective state, in this case, the UK or Grenada. So there's a specific article, a clause, which says that these terms and conditions are recognized to have been made under the laws of whichever country and are therefore enforceable under the laws. Would that make a difference?
Right. I would say that it would make a difference because parties have now specifically said it is that. So it's not as if it's not legally binding. It is a contract essentially, but in terms of enforcing it for the breach in the UK, at least, that's where the issue comes in. It's binding, but breach can go to court. But if there is a specific inclusion where the parties say yes, if there is anything goes wrong, there is some enforceability, I would say that transform it. But the thing is, would an employer want to agree to such a term being included in the collective bargaining agreement? And that's where the issue may arise, because they may say, well, I don't want to be subject to any sort of court action should I choose not to go along with what I have agreed to. But of course, that's not sorry, go ahead.
Could I just interject something here? Because you spoke about the transformation of the laws, right? From 100 years ago to today. Oh, how things have changed, but they remain the same. Because, in a sense, because it therefore begs the question, if an employer does not wish to sign on to an article like this, therefore, you may be back 100 years ago to enforcing those things that you agree from a collective point of view in methods that may resemble 80 and 60 years ago. I just thought I should posit that there for the listening public as we speak about transformation and the point you made about how relationship, a modern relationship, if there is something like this, between the employer, the workers, and the bargaining agent can lend itself to what you call a more conducive, peaceful industrial relations climate along the line of social dialogue.
Right.
Yeah, in other words, you're saying basically, Andre, that ultimately we had to settle it in the streets.
But precisely.
Okay, but I just want to still make this point though, in terms of what Danyish was saying. You can't really be sure because sometimes courts are very jealous of their jurisdiction, and the court may well say that, listen, the issue of jurisdiction is a matter for the court, not a matter for the parties to determine whether the court has jurisdiction in the matter or not. You can't really be sure. But an important point, and it links to one of the points you made earlier. What this shows up, Andre, will be the need for unions, employees, organizations to have the best legal assistance when entering into these agreements. So, for example, as Danyish was saying, the way around it may be to have it incorporated in the individual employment contract of every employee. In that way, now it's an employer-employee situation and not just a collective bargaining arrangement, which is about our policy, because clearly that's an issue of policy on the English law that they take. I'm not sure if that could fly in Grenada though, because with our constitution and the right of freedom of association and all of that, there may be arguments. I'm not saying it's simple, but there may be arguments to say that the situation in England is different. They could pass laws, they have parliamentary supremacy. We have a constitution. So there may be some elbow room. But I just want to how would you view Section 29.5 of the Employment Act, which deals with contract of a continuous basis? Actually, we had promised that we would not go into those specifics because these are certainly, you know, in Ms. Harford practice as she goes along. I'm sure she will have to deal with those issues, but I don't know if it's fair to ask her to deal with that now unless she wants to. So but I wanted to ask you, Danyish, in terms of your English training, and again, you don't have to go into any details. What stood out? What stood out to you in terms of you use different lens to look at what is happening at home, right? You now have this training. Did anything stand out to you to say, you know, back home, maybe we need to repair this, we need to repair this, we need to apply this? And not just to say we follow in the English way, because of course you have been exposed to international standards through the ILO conventions and all of that. So I just want you to, if you could address that.
Right. There certainly is one area where I see we may benefit from adopting that approach. Obviously, transplanting one system from one jurisdiction to another has its challenges. So it's not really just taken wholesale, but at least looking is the different avenues for enforcement that an employee can avail himself to in the UK system that I think we may benefit from. So in terms of things like minimum wage breaches or leave entitlement, health and safety, there are specific governmental bodies, in addition to the tribunal, the employment tribunal, which has jurisdiction to determine those issues. There are these governmental bodies like the HSC and the HMRs. I can't remember what the acronyms mean, but they are governmental bodies specifically designated to deal with these issues, and not in a surface level way. They can actually impose fines and give determining orders to the employer to bring them into compliance for breach of statutory rights, right? So in addition to the court, which deals with everything, including a determinative regime for unfair dismissal matters, which it appears we seem to lack, there are these agencies that can make final decisions, give fines, whatever, to the employer. And there are also impartial organizations, and that is aside from trade unions, right? Which can give advice or provide mediation services, training to the employers as well, on what they need to do. So there are many avenues to ensure that, one, the law is actually enforced, and two, to ensure people are aware of their rights and obligations. And I think this is where we may need to take, a page out of their book, because we have, of course, the Ministry, the Department of Labor, the Labor Commission, and the labor officers, and so forth, and the court. But the court can't really determine unfair dismissal matters, as the Privy Council ruled. Of course, that's not what we want it to be, but it has been ruled as such. And the court can become saturated with matters, not employment-related matters, all the different matters. So having a streamlined tribunal to deal with these employment-related matters might definitely help with these other matters going through the system much quicker, and having some more powers for the actual labor officers in terms of issuing fines, just a bit more enforcement to whatever they are able to do.
Yeah, I think the biggest issue with what you're raising is something that is highlighted by Cyrus Griffith. And it's interesting because he was the labor commissioner for many years. And he says here, I think the most important issue in industrial relations is trust between workers, employers, and unions. As long as that's established, then matters will never end up in the courts. There will be differences and disputes, but I think that, at least from my experience, I think I gather that there's some distrust by some of the parties, even though we're supposed to have a tripartite system, but there's some distrust by some of the parties in terms of having these tribunals, having these parties which can make determinations. I think there's some distrust. Andre, I don't know if I'm if you'll agree with me on that.
No, sure, most definitely. And just to expand on what Mr. Griffith has indicated, that is absolutely correct in his general application. But you certainly will find, as the Privy Council put it, and I don't think I could have put it any better than them. I mean, they have certainly highlighted the approach of this particular employer in the Injure Williams case. This is not about trust, but this is about probably power, right? So you have these aspects to deal with because these are real life situations. These are ideological and philosophical positions many times, because some employers feel that, look, this is my company, this is my business. Yeah, I'm the one who have put out everything, and therefore, who is you or who is that third party to tell me how to deal with someone that I employ? So many times it goes even beyond trust. But yes, generally, I would say in the 90s in terms of the percentage, it boils down to trust. Because if we look at Grenada, it is very few employers, even if you take the Technical and Allied Workers Union, that have over 70-something different collective bargaining agreements. There's a handful of companies that you will hear many times that there's an issue of breakdown in relations. So a lot has to be based on the aspect of trust. Yes, I agree with that.
Yeah, and what you say is, in fact, is a really unenlightened approach, because the fact of the matter is that, and it is proven, that good industrial relations is an asset in terms of productivity.
Sure.
I mean, that's established. So trying to use a heavy hand and in that manner is a unenlightened approach. Jason Skeet says, I want to get some clarification on an issue, but he has not highlighted the issue as such. Let me ask, I don't know to what extent your studies would have extended to what happens in continental Europe, because in Germany I know they have an arrangement where, and it does clearly work for them, where employees are not only they have all of these rights, but they are actually also, although they have a tiered system, they are also represented on the board of the board of directors for private companies. I don't know if you came across that or.
Right. Well, that was not any aspect we delved in substantially, but there were references to how the German approach to industrial relations is very different from the UK approach and even our approach, where they have a sectoral approach to collective bargaining. So it's not, collective bargaining is not restricted to this employer and these sets of employees, and different employers who may be in the same field, the same sector, have different terms with who they. In Germany, they have a
Yeah, we just have a little internet issue there. Okay, we'll wait for Danyish, but Andrea, I see Jason Skeet is asking, what does the law state about a situation in where a company is sold in whole or in part? What are the options of the employees? I think you can answer that easily.
Yeah, sure.
Because it always arises.
Yeah, sure. It deals with what you call successor employer. And in a
Right.
nutshell, without quoting the law verbatim, says that where there's any change in the composition of the company, whether whole, part, lease, etc., the employees of the former employer has the right to determine whether they want to go over to the new employer or they wish to be severed over term and be paid for their years of service. Basically, so that option is this. Basically, as we have said, you cannot sell someone. So in a nutshell, Jason, and I must put up, I understand where my brother Jason is coming from. Yeah. So that's
and
what he said.
Also, if the person decides to go over, they go over with all the rights and all the benefits from the previous employer.
Yes, yes.
Okay. Danyish, you back with us?
Yes. Sorry about that.
Yes.
Yeah, so I was saying, I'm not sure if you heard, I made a distinction of the German approach where they have a more, it covers the entire sector when they engage in any sort of collective bargaining, as opposed to individual organizations or firms doing their thing between themselves and their own employees. So there is some more standardization of any obligations or rights by the parties.
Okay, somebody has asked, can trust exist without integrity? That's just a question/comment by one of the viewers. Yeah, so you said you think that there should be the critical issue. Not only we have rights on the books, but they ought to be in place institutions to enforce those rights.
Yes.
And you think that maybe they just having the labor department alone doing that maybe overloading them and so on. That's what I'm getting from you.
Yes, so certainly it's not any issue with the personnel themselves and any sort of inability to address the issues, but it could be a matter of resources and having the designations of different departments, maybe within the specific department of labor that is just streamlined to deal with that type of issue. And so, resources aren't scattered because there are many different types of issues that can arise in any employment-employee relationship. So having better enforcement of the rights that we do have on the books, I think, is the most crucial aspect, because what's a right without any sort of backing behind it?
And one we haven't really touched on tonight, but will definitely come to the forefront more and more so in the future, is that of occupational health and safety. And we haven't really touched on it. Yes. So there are a lot of issues, and definitely someone, a person as yourself with your skill and expertise, not only from either employer or employee standpoint, but also from a national standpoint, because there are so many issues now. This morning there was a very, very good program carried by Brother Dr. Bob, Kellon Bob, dealing with the issues arising with the movement towards statutarizing the health services and the legal issues that could arise. I know Roberts Ferguson Casey was on together with Mr. Gilchrist, who was involved in shaping Terrence Terran Gilchrist, yeah. So you'll have those issues. I know the issue of regularization. So I don't know if you just want to highlight the kind of issues that the labor movement, that gives rise to those that give rise to concern within and by the labor movement.
Yeah, well, sure. And in the public service, the aspect of regularization, which is another terminology for permanency, right? The interesting scenario that is facing us at the moment, and has been advocated most clearly by the Public Workers Union in most recent vintage, is the interesting approach by the state as it seeks to address the issue of pension, where it has said that it is seeking to address the issue of pension first before it addresses the issue of permanency of the workers. And that for us is a clear indication that the state has recognized that once the workers are permanent, they will be entitled to certain benefits. And they're trying to find a way around, which I don't believe that they'll be successful at. I mean, they can do it, but it will be challenged. And it will lead to further industrial problems that they are seeking to, because Section 29.5 of the Employment Act speaks about three types of contracts. And as was earlier addressed when you spoke about the contract for service and contract of service, there's the aspect of having individuals working for 5, 10, 15, 20 years, purportedly on what you call fixed term contracts, which ought to be a contract of an indefinite period. And therefore, these workers ought to be. In other words,
they give them a 21-year contracts or 22-year contracts.
Correct. Okay. Absolutely. Yes. Because the state has recognized, according to the law, that these workers ought to be permanent. But the state is saying that if we make them permanent in keeping with the law and doing what is fair and right, then we will have to give them certain benefits that we don't think we'll be able to afford at the moment. And that should justice be trumped by costs, or should there be discussion as to how you give these workers these rights, right, to meet those obligations? So there is this concern. Then there's a concern as a question that has been asked here by Jason. If you are statutarizing, what are the rights of these workers to determine whether or not they will go over? There is a constitutional aspect that came up this morning for what you call established workers in the public service. And even those who that you have not considered to be established, but according to the law, ought to be established because they are performing in an established position, although the state or the PSC did not do what is required under the law. So you have these challenges coming up. The aspect of consultation, open engagement with the bargaining agent, because the terms and conditions of workers in a unionized environment is advanced, advocated by the lawyer. And in this case, the lawyer, the legal representative of the workers, is the trade union. So the trade unions ought to be engaged. And what that will do, it will help in creating a more stable industrial relations. At the end of the day, everything may work out, but it will work out with less confrontation. Then the aspect of pay and grade that the union has been clamoring for has not been addressed, or has not been addressed in a open dialogue manner. So all
that's a public workers union you're speaking about, right?
Public workers union and the public sector, right? But in particular, the public workers union. The public workers union that represents the vast majority of the public sector workers. So these are some of the challenges that have been faced. And as has happened in the private sector, there are cases in the private sector where there are change in ownership, and the question of successor employer and the right of the worker to go over or not to go over. And in the case of the public sector, it is more clearly defined under the Grenada Constitution. What would arise if you're seeking to change the employment relationship with the state as the employer and a new quote unquote new entity. So what the union is calling for is a slowdown in the approach, an open dialogue, a meaningful dialogue, sharing of information, and engagement with the union and the workers, and the employer, and the legal counsel. Danyish, as just here, because it is part of the Grenada landscape, under the question of independent contractor or employee-employer, would aspects as to whether or not if the employer or the determines your hours of work, right? When you take your lunch break, what you work with, how you perform your work, would these be factors to be considered as to determine whether or not it's a contract of service or contract for service?
Yes, certainly. Those are very crucial factors because that gives an indication that you are not the one determining your own movements in this service that you're providing. You are essentially subject to the putative employer's control. They are the one really deciding how and what you do and when you do it, as opposed to you having that sort of independence.
Thanks.
Yes. So we leading up to the bottom of the hour, and I just want before I invite closing comments and before I thank you for appearing, to once again recognize the sponsors: Jail Professional Solutions, Jim FM carrying the program out of Canada, and Grenadian Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Yes. So, Andrew, you have any closing comments?
Sure. I just wish to once again recognize and salute Danyish for her choice in her field of study, and to use this as an opportunity to encourage more workers, more people to get involved in employment and industrial relations law. The labor movement really do need much more. And I see Danyish approach and her baptism with Siboney Chambers as a very good foundation for the pursuit and continuance of fighting for social justice and workers' rights. Because although, as she has quite rightly said, employment law is not just about workers, but certainly one social consciousness will determine to a large extent the area that or where one give preference to who one wish to represent. And that certainly will be an individual decision. I'll be very happy to have Danyish continue along the veins of Siboney Chambers in terms of service to working people. Because the challenges that we face today are much more than just hitting the streets. The challenges that we face today is more in the boardrooms and certainly may be headed for the courts. And therefore, we need people like Danyish who have the academic fortitude and exposure to help guide us as we pursue the rights of workers and wider Grenada as a whole. Thank you, Mr. Layne, for having me on this program as a co-host. And for this particular program that I'm sure would whet the appetite of quite a number of workers and other interested persons who have been listening, and those who will tune on to hear the recordings. So Danyish, once again, thank you very much for engaging in that field of study. And I will ask you to use your resources to do networking throughout the Caribbean region, which you ought to have gathered from your engagement with UWI, because that would be one of the major advantages of studying in the West Indies, UWI, the aspect of developing networking, which we should use to our advantage in our Caribbean or West Indies civilization. So once again, thank you very much.
Yes, Danyish.
Yes, thank you, Mr. Lewis. Thank you, Mr. Layne, for having me here tonight and giving me the opportunity to give some insight into the course I undertook and generally into some employment law matters. As Mr. Lewis indicated, and Mr. Layne, very salient issues arise. The fact that adults spend most of their lives at work really it should give you, right there, right, just so you know, it's very, very important to be aware of your rights and your obligations as employer and employee. So thank you once again. And I look forward to more sessions like this.
Yes, I want to thank both of you for coming on, and just to make the point, that stable industrial relations environment is an asset. It's an intangible, but it is a valuable asset. It's one of those intangibles that you will find economists who will actually put a value on it when they measure things as GDP and all of those things. Certainly, for small nations as Grenada and the Caribbean, where we seek to attract investment from outside, foreign investment, and by that I mean serious foreign investors, the state of the labor environment is always an issue. And we don't have to take the approach of seeking to bring back virtual slave conditions in order to attract foreign investors. In fact, more enlightened foreign investors today, they look forward to and they look towards working in a progressive environment. And certainly with the power of social media, the power of the ability to expose, when these companies engage in conditions that are oppressive, and the fallout they get from that, they are very much aware. That's why even in terms of businesses, there is something called today that they pay a lot of attention to corporate social responsibility. And in terms of how you treat with workers, that is one of the factors that people who study this field have concluded that they actually add value to companies. So it is not something that we should in any way underestimate the role that the industrial relations environment, the role that it plays, and the role that lawyers could play, the role that trade unionists could play, the role that enlightened people could play in terms of establishing this kind of environment that will really redound to the benefit of our nations and to the benefit of our people. Again, Andrea, I want to thank you for agreeing to co-host this program. And Danyish, I want to thank you for coming on. Next week, Sunday, we will have a panel that will examine the CCJ decision in the case of the British American policyholders versus the government of Trinidad and Tobago. Yeah, it was a case where, ironically, many workers across the Caribbean, they lost everything, including their pensions. So that is next week. We are expected to have Dr. Kenny Anthony, who was the one of the persons on the team of lawyers who represented the claimants in the matter before the CCJ, former Prime Minister of St. Lucia. In fact, he was the Prime Minister at the time of the collapse of CLF, and he will tell us that St. Lucia is one of the few countries in the OECS that was not adversely affected by the collapse and the reasons why. And we also expect to have Dr. Patrick Antoine, who is the head of the president of the policyholders, the policyholders that the organization representing the policyholders, which took the matter to the CCJ. And we also will have, but pre-recorded, a contribution from an international trade lawyer operating out of Europe. So that will be the program next week. Thank you to all those who viewed. Thank you in advance to those who will look at the program after. It was my pleasure and our pleasure to carry this program. Thank you and good night.
Good night, everyone.
Good night. Thank you.
Okay, bye.